Hi, this is Kelly Allen. I'm going to discuss a concept that you may not be familiar with, and that is crimmigration. It's the combination of criminal law and immigration law. And it comes up very routinely, and it's critical for anyone who is not a U.S. citizen who is charged with any crime to be aware of, because you don't necessarily realize it. But if you are not a U.S. citizen, and that can be you're a permanent resident, possibly you have asylum status, temporary protected status, DACA, you're here on a visa, or maybe you have no legal status at all. Any one of those situations can be significantly impacted if you are charged with any sort of criminal offense. So it is crucial that if you are charged with any crime, before you eat, and you're not a U.S. citizen, before you even consider accepting any sort of plea arrangements, you need to be very sure of what the immigration consequences may or will be. Sometimes the consequence is absolutely certain that if you plead guilty or convicted of certain types of crimes, that the immigration impact is readily known. Maybe it means the impact might be that it won't cause a problem, but the impact might be that you would definitely be removable, that you would be placed in immigration proceedings and wind up having to leave the country, and that there would be nothing that anyone could do about that. Um, Sometimes the immigration consequences are uncertain, and it's really crucial that your criminal defense attorney be very well versed in immigration law, because immigration law makes very little sense, truthfully. And there are a lot of differences between criminal law and immigration law. For example, you could have a criminal charge dismissed, but all dismissals are not equal when it comes to immigration law. In fact, many types of dismissals for criminal law actually still count as convictions under immigration law. So you could technically have a clean criminal record, but still be removable from the United States because of a criminal issue that immigration law considers a conviction. Another huge issue is expungements. If you have your record expunged, then for criminal law purposes, you no longer have that conviction. Well, not so with immigration. Immigration law does not recognize expungements. So it has absolutely no effect on your immigration case to have your criminal record expunged, because it's still going to count. And in actuality, it can make things more difficult, because if your criminal record is expunged, records are destroyed. Immigration needs records for anything that you apply for, so it can actually make your immigration situation worse. There are other things that are counterintuitive when you're looking at possibly whether to accept a plea deal or not. When you're a straight criminal defense attorney is looking at the situation, they're generally trying to look at, okay, what's the least amount of the fine, or what's the least level criminal offense we can plead to, or what's going to minimize potential jail time. And all of those are very important, very valid considerations. But if you're a non-US citizen, you've also got to throw the immigration considerations into the mix, because you may decide, oh, it might be better to plead to something or even have a sentence that includes a little more jail time if that conviction is not going to cause you to definitely be removable from the United States. Whereas having a different type of plea arrangement that maybe minimizes jail time would result in your removal from the U.S. So there are all sorts of those things to consider. So I would advise any non-U.S. citizen who is facing a criminal charge to either also consult with an immigration attorney or hire a criminal defense attorney who also practices immigration law. it can make a huge difference to you.